The right to a public trial. Sixth Amendment in all criminal prosecutions. The accused shall enjoy the right to a speedy and public trial. The traditional Anglo-American prohibition against secret trials is rooted in the menace to liberty practiced in the English Star Chamber. The guarantee of public trials is a safeguard against corrupt courts where, as here, a wealthy individual is stripped of her freedom and dignity, drugged, and forced to watch her estate be siphoned off by professional court appointees. Quote, as a minimum, due process requires that an accused be given reasonable notice of the charge against her, the right to examine the witnesses against her, the right to testify in her own behalf, and the right to be represented by counsel. And that comes from In re Oliver, 333 U.S. 257, page 273, 1942. The Supreme Court said that to perform the high function of weighing the scales of justice equally between contending parties, justice must satisfy the appearance of justice. Unquote. The Supreme Court found that the judge authorized by Michigan law to act as a so-called one-man grand jury cannot consistently with the due process clause of the 14th Amendment summarily convict a witness of contempt of conduct in secret hearings. Unquote. In the Britney Spears case, Britney was traumatically 5150'd twice in 1 month in January of 2008, with cops and firemen breaking down the door, ambulances, sirens, squad cars, helicopters, and paparazzi, 40 to 50 of them. When Cedars-Sinai sent Britney home, because there was nothing wrong with her, a second 5150 was orchestrated. This time, the parents found a doctor who had never treated Britney, got them to consult with her one time, and prescribed medication, which she took. But shortly after that, even though Britney was taking the medication, the doctor signed a statement claiming that Britney was not taking her medication, and the police, firemen, paparazzi, and helicopters went into formation again. 3 weeks after the first 5150, Britney was 5150'd again. Helicopters, squad cars, paparazzi, and an ambulance went to her home, and again her door was broken down. This time she was taken to UCLA, who was willing to restrain her while letters of conservatorship were obtained without notice to Britney in a 10-minute secret hearing by Judge Reva Gertz. Judge Gertz appointed Samuel Ingham to be Britney's attorney, who reported to the court that Britney was unable to make her own decisions based on a 15-minute interview at the hospital. There was no court investigator. Britney's attorney, Mr. Streisand, was ejected from the court when he attempted to represent Britney because, according to the court, based on Ingham's report, Britney lacked capacity to create a contract with Mr. Streisand. Here, as in the Oliver case, one person, in this case Judge Gertz, acted as a one-man grand jury, acting inconsistently with the Due Process Clause of the 14th Amendment, summarily depriving Britney of her liberty and property in a secret hearing to which she was not even invited or given notice. Under the protections of the 14th Amendment, she was entitled to a public trial, as distinguished from a trial in camera behind closed doors. The reason for this is, quote, so that the public may see that she is fairly dealt with, unquote. The fact that Britney was given no notice of the hearing, not allowed to be represented by her attorney, and not allowed to confront her parents who were testifying against her so that she could cross-examine them. Her attorney should have been able to cross-examine her parents, and the case would have never made it past that stage because the declarations of the parents are totally lacking any substantial evidence against her. Quote, "It is important to remember that every hearing has a due process standard commensurate with it. In 2006, the California State Legislature enacted the Omnibus Conservatorship and Guardianship Reform Act of 2006. Quote, for example, the court must interview the proposed conservatee to ascertain whether he or she objects to the conservatorship or the proposed conservator. If the proposed conservatee desires to oppose the appointment, the court must decide whether he or she is sufficiently lacking in capacity to require appointment of a conservator." Unquote. In this case, there was no legitimate interview. The interview was conducted not by an unbiased court investigator, but by the court-appointed attorney who stood to gain and did gain $3 million in attorney's fees over the course of the 13 years that he served. Based on a 15-minute interview in the hospital between the attorney and the proposed conservatee, who had no knowledge of the proceedings until the court-appointed attorney walked into her hospital room after she had been traumatized by the two 5150s. The attorney reported to the court that Britney lacked the capacity to hire her own lawyer or to make a rational decision as to whether or not she objected to the conservatorship. The due process in this case fell short of the standard of due process required by the Conservatorship and Guardianship Reform Act of 2006. We must always guard against abuse of psychiatry, the misuse including diagnosis, detention, and treatment for the purpose of obstructing human rights, in this case, for the purpose of taking from Britney her massive fortune. The strategy is referred to as isolate, medicate, and liquidate the estate, and it's known to be fraud endemic throughout the probate community. It is the deliberate action of having a person psychiatrically diagnosed who needs neither psychiatric restraint nor psychiatric treatment. The abuse of psychology is used to conceal the repression of dissent and evade prohibitions against punishment outside of the process of due process protection. In Britney's case, she's not a dissident in the usual sense, but being a female who raised her head above the heads of others, she was treated to the same type of persecution that we give to nonconformists.